We are moving from equity to advocacy. And the topic that we are going to listen to now is something that I think interests all medical practitioners all over the world. Medical negligence, precepts and perspectives. We have a very distinguished speaker, Dr. Karunakaran Mathiharan. I was looking at his CV and I was wondering how to summarize it because there are so many achievements. Dr. Mathiharan is an alumnus of Madras Christian College, where he did his BSc, and then he did his MBBS and post-graduation from Madurai Medical College, and continued to work towards his PhD in the Tamil Nadu Dr. MGR Medical University. He has probably worked in all the government medical colleges in Tamil Nadu, being in government service, but then he moved to Malaysia and he served at the University of Malaysia Medical College in KL until 2016. He has returned to India and he continues to be active. He has a huge list of publications, but what interested me were more than his scientific publications, the fact that he has chosen to write for the lay public on medical jurisprudence, including publications like the Hindu and various news magazines. He's been a reviewer for Indian Journal of Medical Research, National Medical Journal, as well as the BMJ. And he's also the founder of the Indian Legal Institute. I hope he'll tell us a little bit about that I'm not familiar with their work. So I think today, as he talks to us about precepts and perspectives of medical negligence, this is something that we all need to know, not only as individual practitioners, but as institutes. So we look forward to hearing from you.
Good morning to everybody. Two things I want to say before I commence. One is, my throat is under repair, so I may fall sometimes. My voice may fall. The second one is, this topic requires whole day session or at least 2 to 3 hours for me, but I've been given only 25 minutes. So I'll try to do some justice. So the topic is on two things. One is precepts, that is theoretical aspects, and the second is perspectives, the cascading effects of medical negligence. First, medical negligence started, we find the mentioning of it 4,000 years back. During the prehistoric times, we don't know how the hunter-gatherers dealt their shaman or the medicine man. But first time we come across it in Code of Hammurabi from Babylonia in 4,000 years back. And the contemporary Middle East and Egyptian civilization and Chinese civilization. How they dealt, when they found medical negligence, it was amputation, whether it is the elbow level or neck level. So that was the situation, death penalty or amputation. Coming to India, it was called as Mithyabachara by Sushruta as well as Saraka. Here, probably our country believes in non-violence. The punishment was fine. But the fine went to the government or the local king, not to the patient or the relatives of the patient. This scenario says medical negligence was dealt more as a crime. And in a crime, the sufferer, that is the patient, never gets any relief. The next stage comes from UK as the parliamentary democracy as the common law was developing in that country in 14th century, that is 1378, we come across the first medical negligence case that gives some relief to the patient. Since then, next 500 years or so, not many cases, only sporadic cases where compensation was awarded. This is called as tort law. Tort law means civil wrong, which tries to give some compensation to the patient or the workers. See, in the 18th century, as you all know, industrial revolutions was happening in UK, and as a result, compensation, Workmen's Compensation Act was enacted, and the law of tort, the tort law also developed in a big way. As a corollary, in 1838, for the first time we see in the medical negligence case, standard of care. Doctor is expected to exhibit reasonable care and skill. That was the first time. First step, we can even say that. Later, this beginning of 20th century, so before I go there, what are the legal avenues available for a citizen of India to sue a doctor? First one is, he can lodge a complaint with the National Medical Council, that is State Medical Council. What they can do is, they can ask the State Medical Council to go into the thing. The maximum punishment is temporary or permanent debarment from practicing medicine. Most often it is only temporary. That too only in the recent times. 1 week, 1 month, or 6 months. But the patient never gets any compensation. As the second one is civil courts. Civil courts take a route, the complaint is filed in a sub-court, then appellate court is district court, then the high court, then the Supreme Court. Here, a patient has to pay a court fee to file a case according to the compensation. But this court, for instance, I'll tell you, in 1963, July, a patient died of peritonitis or septicemia shock, subsequent to a sterilization surgery in Maharashtra. This case reached its final stage, final order from Supreme Court of India in 1996, February. That is, it took 33 years to get a final verdict for an amount of 36,000 rupees. So that is the kind of delay you come across with the civil court. Next comes writ petitions, public interest, PILs, public interest litigations. Here, writ petition means most often it is filed against a negligent complaint from a government hospital, usually government hospital. Public interest litigation means some of the wonderful orders on emergency care, HIV care, or what is the thing? Any euthanasia, all are result of public PILs, especially since 1989 to till date. Most of the cases are PILs, and it can be either filed in the High Court or Supreme Court. Then comes Indian Penal Code. Usually, when a patient lodges or the relatives gives a complaint to the police, it is taken into the file and under IPC section 304A, which is used, interestingly, in motor vehicle accident also, road traffic accident also, for rash and negligent driving. So here, when a case is filed against a doctor, it is considered as rash and negligent way of handling equipment and causing the death of a patient. So this section entails the arrest of the doctors. So in 1998 in Tamil Nadu, one doctor was awarded 10 years rigorous imprisonment because he was filed under 304, which is called as culpable homicide. In other countries also, when a criminal complaint is lodged in US or UK, it is called as manslaughter. This is a section used. I don't want to go to the intricacies. I will say, subsequently, Supreme Court of India in 2005, they issued an order on this criminal medical negligence, and which very clearly says nowadays a doctor cannot be directly arrested In the case when a police receives the complaint, he has to refer it to a nearest medical college hospital for an expert committee to be formed, and their opinion is taken before proceeding further. This is the state of criminal medical negligence. Next is Human Rights Commission. See, in 1948, United Nations passed the Universal Declaration of Human Rights Act. And it was adopted by our country also as a signatory of the UN Convention. And so it is admissible in our courts also. In 1994, National Human Rights Commissions were formed in the state level as well as national level. They can, as first time in the international declaration, health was considered as a fundamental right. Universal Declaration, Article 25, recognized is a right to health is a fundamental right. So this was adopted by various courts of India, and National Human Rights Commission on that basis, national also state human rights commission can take up any complaint from the patient or suo motu any negligence reported in the media, they can take up and award compensation. That's one way. The last one is Consumer Protection Act. When you talk about consumer movement, it actually started in 1962. And the first 4 declaration was announced by John F. Kennedy, then US President. Later in 1985, United Nations adopted the consumer protection. And Indian government also passed an order in 1986, and it was notified in 1987. And it also was amended in 2019, and it was notified in 2020. So what is the structure? Next item. This is the structure of the consumer court. At the district level, all districts of India have district commission. They got original jurisdiction for a claim of 10 million or 1 crore. That is, they can directly receive the complaint for up to a claim of 1 crore. And this commission is presided by a retired district judge, and 2 more non-judicial members will be there. So majority judgment will be the majority we have to accept for a judgment to be implemented. Next level, state commission, every state capital city will be having it. In Tamil Nadu, state commission is in Chennai, as well as there is a bench comes to Madurai for certain days in a month. Because of High Court bench is there in Madurai, so they got it this also. Their jurisdiction directly 100 million, that is 10 crores up to a claim of 10 crores, and any appeal from the district commission. Above this, in Delhi, there is a national commission. Of course, state commission is presided by a retired High Court judge, and 2 more members are there. Above this is national commission, and it is in Delhi, and it is presided by a retired Supreme Court judge, and there will be 4 members. 2 High Court judges, retired judges, and 2 more non-judicial members. Final appellate, their jurisdiction is any claim, original jurisdiction, any claim above 10 crores, and any appeal from the state commission. Above this, the final Supreme Court. 4 tier. To my knowledge, the highest compensation was awarded by Supreme Court. That is, it was originally filed in the National Commission and then went to the Supreme Court, and it was 2014, I think, Gunal Saga, and that awarded 6 crores 8 lakhs. That was the first, but above 1 crore judgments are very common. So when I was active in this field as a consultant, that was in the 2000 beginning and up to 2010. In the district courts, even 25,000 was a big award. In the state commission, few 100,000. So that is 100,000 or 200,000, like that. The state, I mean, above this, if you go to the national commission, used to be 4 lakhs, but now it's running into crores. Some salient features. For any claim to be filed in the consumer court, it has to be adjudicated within 90 days. If there is any investigation to be done, it is 150 days. But unfortunately, this time limit is not at all followed. Even we ran cases for 10 years in the district court itself, National State Commission. So that is the way they are functioning. See, initially, for a medical profession to be included under the Consumer Protection Act, there were a lot of objections. And even the court orders, for instance, the Madras High Court initially objected to it, then they accepted. Then it went to the Supreme Court. In 1995, in Indian Medical versus VP Santa, they gave the final order. I will still, even I call it as a proactive order. Why it was done? It is a definitely beyond this session. I will tell you if you come to me and I talk. But one thing I can say is after this, it's a bench order. Nobody questioned it. 28 years gone, and it is functioning. So what is the definition of medical negligence? First, duty of care. Usually in the court of law, it is established by the prescriptions we give, or the discharge summary, or the investigative report, such that, or the receipt, fee receipt. These are the things. This is probably easily that can be confirmed by the patient. Second is, doctor did not display reasonable care and skill. This reasonable care and skill has been so many times undergone a lot of modification, and standard of care they evolved to a different scale. That is, in a given place, it should be what other doctors are practicing, that is the reasonable care and skill. And then they came out with a Bolam test, that is we have to explain in a big way. I will say simply, this aspect has to be proved by established by the patient or the complainant, not by the doctor, with the help of another expert. The last one is whether this lack of or absence of reasonable care and skill resulted in the damages suffered by the patient. That is the third aspect. That also has to be proved by the patient. So this became very difficult. Probably I will come to the final thing, how it affected. And for a doctor, two things I want to say. In an emergency situation, the doctor can take any steps. That is, the court gives wide latitude for a doctor to choose the kind of treatment, and it need not be a reasonable care and skill. It never falls. And moreover, there is no definition, legal definition for emergency or critical care. It is we say emergency, it is critical care. That's the thing. So next, whatever treatment choice, when there are two recognized methodologies are available, doctor has a right to decide which one to follow. So I take an ethics, it's simply we say morally which is right and wrong, because other sessions are dealing with that. I'm looking to only the autonomy. Autonomy is the first principle of ethics, modern day ethics. And in a court of law, it comes into the expressed as the consent, informed consent. What is the informed consent? You are supposed to tell the patient everything about the treatment, alternate treatment, what is good in this, what is bad in this treatment, and the alternate treatment, and what will happen if the patient does not want to undergo the treatment. More important, what is the expenses involved in both the time. Very important, it should be in the language known to the patient. Since in spite of all saying this for more than so many years.
I think we have 5 minutes more.
5 more minutes. Okay, then I'll skip that. Okay, now I will come to this one. What is this? Perspectives. See, one thing I said, 1858, for the first time, until then, the medicine was there was no question of fee for service. 1858, UK Medical Act was enacted, and this also conferred the right to collect fees from the patient. Same thing came into the picture in 1916. And in 1914, one of the New York, in a US judgment, for the first time it said, every adult human being of sound mind has a right to decide what to do with his own body. That is the basis of informed consent. And it developed in a big way. And meantime, many doctors refused to come to the court to give expert opinion on medical negligence claims. So it was called as conspiracy of silence. And the court evolved certain ways called Precepts, where the burden is, see, patient went with a good body and he has come out of the dead body. Give the explanation. Doctor has to explain. This is called a Precepts. So finally, now slowly, right to health came into the picture. First time it was found, the word is coming into that 1948 WHO Declaration. Then second thing is 1948 Human Rights Declaration of UN Declaration. Third, our own constitution in 1950, Article 21. Then International Covenant, Economic, Social and Cultural Rights, 1966. Then comes World Medical Association also has a declaration on patient rights in 1981. The final one is Rajasthan Health Act, Right to Health Act in last year, 2022. So right to health has a bearing over the medical negligence. See, there is an imbalance between the patient and the doctor relationship. To balance it, all these rights has come into the picture. And moreover, I have to tell you this one. I told 100 years back, there is a Tamil hymn from Nalayara Divya Prabandham, which says, Valal Aruthu Chudinim, Maruthuvan Pal Malada Kadal Noyalan. Roughly translation, even after amputation and cauterization, the patient respects and loves his doctor. This 1200 years back. This is what it shows is the implicit trust. That is what missing now. See, this is a factor. I put it this way. Healthcare is not a single entity, and doctor is not. If you think doctor is the center of medical profession, medical care, just deconstruct that idea. Now, so many factors. First, as a biological organism, health is meant for survival and propagation of species, Darwin's code. Then comes social, cultural aspects. Each one has its own cultural feelings for the medical. Every culture has got it, tribal culture. And here comes, okay, I stop.
Okay, 5 minutes more.
One more thing is, I'll give. Last one. This one, I will leave it with your team. You can collect it. 5 minutes. Okay, I'll explain then. Then legal comes. When you say social, legal aspects, which we discussed now. Then comes politics. In a way, medical healthcare is a political dispensation. Politics decide how many doctors you require, where the hospital should come, whether it should be privatized. Everything comes from the politics. Our lawmakers. And previous session, the speaker said, private healthcare is going to be there. Private medical education is also will be there because our lawmakers and our highest court also has accepted that fact. But what we want is regulation. Unregulated privatization is not at all good for anybody. Yesterday, Prof. Ravi was telling us, wherever health insurance was introduced, whichever country, it failed. Same thing. You look into every country wants to introduce a perfect healthcare system. Nobody has succeeded. US, it has become an election point. UK, NHS, same problem. Australia, New Zealand, Sweden, they had a universal healthcare. But where is the problem is delay. The patient cannot just enter and get his treatment. He has to get a treatment, he has to get a date, and it may be after a month or two. That's where the problem comes. This is the political setup. Each society has a right to decide its own healthcare delivery. Then economy, a lot of people talked, I don't want to go into. Science, religion, of course, religion decides. For instance, take MTP, it's religion. Ethics, everybody talk, finance, technology. Last one is technology. In the last 4 decades, you see so much of technology. See, what used to be patient doctor, now interface is technology. What used to be anthropocentric, that is human-centric, now has become a technocentric. That is the current status of medical profession, and we are going to get more. AI, ML, for instance, take mRNA, it's a revolutionary therapy. We think only vaccines, what it's going to do, and what they are doing with the zero transplantation, mutation, and putting it. So many things are going to be in the next few years. Where we stand, have we discussed? Last one, what we require is introspection. One thing, after two decades, almost 15 years later, Prof. Anand resurrected me, and I'm here talking to you. But I see a lot of youngsters, but individually, sporadic, here and there. Have you ever talked about the violence against the doctor in the casualty? What is the reason? Second, so many doctors are going to come out. Government itself says 100,000, more than 100,000 seats. And many doctors are coming out from these foreign countries. And if we include Ayurvedic, Siddha, everybody, there is roughly 150,000 doctors per year. Do they have any plan to engage them or employ them productively? But there are many, when I hear so many people talking about where there are doctors are necessary. See, as a doctor, everybody has a right to have a decent livelihood. So government has to invest in primary health center, and these doctors has to be posted there at least for 2-3 years with some incentives. And moreover, last thing, specialization is not the end. At this rate, see, we should know one thing. Specialization is knowing more about less. And moreover, at this rate of specialization, we will have a specialist for each chamber of our heart. I remember a quote from Brothers Karamazov, Dostoevsky's book. In 1850, he says, there will be a doctor for right eye and there will be one more doctor for left eye. So we have to do a lot of introspection and collective. What I want is whatever has been discussed is to be taken forward. Sustainable, continuous monitoring and movement should be there, and we should not react. Nowadays, everything is thrust upon them, upon us, whether the courts and the public policy makers. But we should come out. See, we don't have a protocol for standard protocol for euthanasia or IVF. Yet nothing. Everything is coming from up, and it should be done by the experts. So many are there. Okay, thank you very much. Bye.
Thank you, Doctor. Actually, I have 4 questions. I don't think we have time to take 4 questions, but there's one which I think interests most of us. In the case of medical negligence, most patients or families of patients immediately choose violence against the doctor. How can we legally deal with this?
See, violence is the expression of grief. And very often, see, I worked in the mortuary. We have come across many violent people, where all of them used to be under the influence. Because in our culture, when somebody dies, it's better to have some liquor. So that's the way. But we have to be very patient. I will tell you one thing. All these incidents, when I saw that Assam doctor being kicked out, or the West Bengal doctor getting head injuries, or this recent Kerala lady doctor dying of stab injury, all these things, see, had it been very clear that patient was a drug addict, he might have been under the withdrawal symptoms, but nobody noticed it. So one more thing is, everything happens mostly in the government setup. Probably in the private corporate, they may be having bouncers, to honest. But in the private government hospital, we don't have such setup. So what is happening is, some junior doctor is there, not much of infrastructure facilities. I used to say we should have counselors. If I am permitted, I will tell you one small incident. What happened yesterday evening? I was sitting there outside, just listening to the sounds of the birds. Suddenly, the security man was talking to one man. He couldn't understand even a single word of Tamil. And what I learned one thing. He came for OPD services, which used to be in the morning. But that fellow only understands Hindi. So I got only basic Hindi knowledge. So I told him, what is the problem? I asked the secretary. He said, only tomorrow morning, 8:30. So then I told them, you have to come tomorrow morning, 8:30. So then he showed me something. It says consultant services in the evening. So I said, it was all in English. See, this is the communication gap. That's why I said, when you take informed consent, you should be in the language of patient. That's more important. In UK hospitals, you won't believe. There are Tamil translators available in the hospitals. There are about 20, even some remote language for Africa. From Africa, they got a translator. And another important aspect is, like any other Western hospital, because we follow Western system, counselors are more important in the casualty or emergency ward. That's very important, because doctor cannot express clearly. Our training is not at all having any aspect of communication skill. Communication skill is very important. In fact, if you ask my experience, I have handled so many cases against doctors. I know very well the basic is lack of communication.
Thank you, sir. The others who have sent questions, I think you can meet Dr. Mathiharan outside and discuss with him.
I invite Dr. Joyce to hand over a token of our appreciation to Dr. Mathiharan.